Matthew Larosiere is a senior partner at Larosiere, the nation's leading for-profit civil rights and consumer protection firm, and is actively involved in the firearms industry. He writes on the subject of Second Amendment, gun law, taxation, and gun violence. His work has been featured in Playboy, National Review, Cato Blog, Fox Nation, Forbes, Wall Street Journal, and more. Matt hosts the Gun Law Mythbuster YouTube channel. Please welcome to the stage, Mr. Larosiere.
Hi y'all, thank you so much for having me again. So I've worked in the civil rights space for most of my career, and in that I've encountered closely all of our favorite friends, the government. I've worked with nonprofits, I've worked in the for-profit sector, and I've noticed something that a lot of people are able to get together on an idea, right? On something they want. And they're really good at failing to achieve it. And who's the best at failing to achieve a stated objective? The government, right? So, why is that? Have we ever thought about the reasons why the government is so uniquely bad at doing what it sets out to do, right? I mean, it's often been said that the best way to figure out what a bill is going to do is to look at its title and just invert it. Just what's the opposite of the title? Well, it's not just something that's magical about government. It's really a question of economics. And I'm sure some of you have heard of the concept of concentrated benefits and diffuse costs, right? And by the way, at the end of this, if you have any questions specific to gun stuff, I'd be happy to take them. But I'd like to take us down an interesting hole onto why we haven't been able to succeed in a lot of the areas that I think victory in sense is ripe for the taking. So, to think about why government always fails at its stated objective, we have to like grapple with this concept. So, I think to start with, I've got an artifact of our stupid system right here. I've got 20 bucks. So, if the objective for this $20, right, is to maximize my benefit, who is the best person to spend this $20? Well, some people might say it would be me, but that's ridiculous. That's stupid. It might be my wife, Sam. We might get a little further along. Maybe it's somebody who I went to college with, a good buddy of mine, right? They know what I'm into. They could probably get something that I'd get some utility out of. What about a high-functioning alcoholic 25-year-old in Washington, D.C. that's never met me, right? As we get further out there, and that's the government, by the way. Those of you who've never been to D.C., that's who runs the government. It's a bunch of high-functioning alcoholic, late 20s people. That's what they're doing every day. They're spending your money purportedly for your benefit. Well, when you actually dissect that, what's happening is all of the benefits are right there in DC. And all of the costs are diffused across the entire United States. So while the purported purpose, right, is still, we need to spend that $20 for Matt, well, all of a sudden, the $20, who am I going to really report to, right? Is I got 1/16% from everybody? They're not going to say something to me. So, maybe Matt wants, a new gun, but, if I sold it through my shop and, we had a little transaction fees and this and that, no one would be any the wiser. That's why government cannot accomplish what it does, because all of the benefits of those bizarre fringe decisions are concentrated in government, and all of the costs are spread out across everyone else. So what do we naturally do instead? I work in gun rights. People want to do gun rights. So what do? Well, we're not going to trust the government to fight for our gun rights. Like, that would be stupid. We're going to trust an NGO, a nonprofit. That's not a high-functioning alcoholic 25-year-old in Washington, D.C. No, it's a high-functioning alcoholic 30-something-year-old in Northern Virginia. The problem doesn't go away. The problem is lack of proximity to the cause. The problem is perverse incentives. I think that nonprofits are a scam. They are incentivized to set up these bizarre structures that resemble government to avoid paying really minute amount of taxes that would otherwise be avoidable, and then sweep all of this money that they've collected from donors under the rug, all to do what? Fail to achieve a goal so that they can do it again next year. I think that this problem has gotten a lot worse in recent years, especially in the gun scene. Maybe that's just because I'm closest to it, but it's a huge problem. We're not seeing progress. We're seeing our rights continuously stripped away at every level. We're seeing millions and millions of dollars pumped into NGOs who are happy to spend it and then ask for more. And is there real progress? Is stuff really happening? I mean, I would put that to the audience. Are you happy with how the restoration of your civil rights has gone?
No.
No. But who are you going to go to? Who are you going to complain to? You can't think of a human face, can you? That's why I, frankly, left the nonprofit space. I didn't want to continue to be a part of this machine. And I thought back to, by the way, it's Thomas Sowell, who I stole that whole idea and conception of the dollar thing from. It's like, well, who is the best person to do this? To fight for gun rights. Look, I don't know anyone who has a more bizarre fixation with firearms than I do, so I'm just going to do it. It doesn't cost that much. And it doesn't just apply to gun rights, it's for everything. I've represented high-profile criminal defendants where the federal government has aggressively gone beyond its space, where the nonprofits won't step in because it's not profitable. But as an individual, it all comes down to your time. And we all have some amount of time that we can donate to our cause. I think the solution is that we need to form more localized groups of people that agree on a core objective, that you're accountable to each other. In the gun rights space, what I think that looks like, and this can translate into any issue area you want, right? Because how things get solved legally is through lawsuits. Lawsuits are brought tactically. You pick your jurisdiction, you pick your angle of attack, whatever. You don't need to be a lawyer or have a lawyer in your group to do this. You need to have people who are responsible to one another, who are focused and motivated on a goal, to be able to agree on that goal, agree on an action plan to do something, right? Let it be a lawsuit. I mean, as a legal lizard, right, that may be the only way I can see to do it. It doesn't cost that much. It doesn't have to be 15 $70 million a year organizations to bring repeated failed lawsuits. No, you in your local community can get together, fund a lawsuit, have a local attorney who is responsible and accountable to you to do it properly, I think that's how we actually make progress without the intense amount of waste that is attended in going through government, or effectively, quasi-government. It really comes down to, if there's a change you want to see in the world, if there's a right that you feel is being violated, you are probably the only person who will know satisfaction in seeing it done properly. And not everybody has all the time or skills or finances to do it entirely themselves, but I bet you know 3 or 4 people who could. I bet you may be part of a, I don't know, some sort of club that meets at a mountain in Alabama. I don't know, right? But I'd like y'all to think about that, because I know that we all hate the government, but do we know, or have we really thought about why the government is so unbelievably bad at helping? And I think it's for the same reasons that a lot of these mismanaged nonprofits are bad at doing it. I believe they are so far away from the people who are affected that success and failure really only comes down to a checkbook. What the small community that I'm involved in has been able to accomplish, we reversed a federal a change in the definition of a short-barreled rifle in the state of Florida. You know how much money that cost? Give a guess. How much money do you think we had to spend to do that? $400. Wow. Yeah. They're excited, but it doesn't cost $50,000. That's what people want you to believe. It doesn't. It's not that expensive. Filing fees in state level are usually like $400. Federal court, $400. State level, like $200. It's not that crazy. It's not that hard. We need to demystify this stuff. We need to show it's possible to have success. It is possible to do it, and we don't need bloated executives sucking up all the money. I mean, you guys probably know more than anyone else, right? Y'all have been running this party for a long time. Your budget's probably not in the multiple millions, I don't reckon, right? I mean, I'm sorry. You've been able to make it happen. You can make big things happen with hundreds of dollars. To give you guys an update on what's been going on in the gun space, just as a quick thing, it's been unreal. Both on how aggressive the government has been, and then how hilariously they're losing. And they don't appear to be stopping at any point. And that's why this is such an incredible point in history. The government is sitting there with spaghetti pouring out of its pockets saying, "There's no spaghetti in my pockets." And everyone is just sitting around with their hands behind their back, instead of going up and saying, "Hey, idiot, there's spaghetti out of your pockets, I'm suing you," right? So we represented a YouTuber who was accused of talking about drawings on a piece of stainless steel. This is the auto key card case. And it was a card with a drawing on it. The government was in the position that that was a machine gun. Yeah, no, it makes sense, right? Because, well, so the government went under a theory that said, so basically the law, there's 5 definitions of machine gun under the law. 2 are important here. One is a part designed and intended solely and exclusively for use in converting of a machine gun. And another is a combination of parts designed and intended for use in converting a weapon into a machine gun. For some reason, the government exclusively said, no, that card, that single piece of steel, is a combination of parts. So the whole trial, we're like, it's one thing. You can't, like, no, that's not how it works, and it's not a part, it's just a drawing. And the jury convicted on that theory anyway. Juries are, I'm not going to speak much about juries, but it's clearly an error of law. We had, we moved for a directed verdict, we had moved for judgment of acquittal, we had moved to set aside the indictment, all on the grounds that, hey, a drawing can't be, if you look in the dictionary, a combination of parts. So that's what we're up on appeal at the 11th Circuit, and it's a very strong case, and I've had help from people who have litigated at the Supreme Court and upper levels that are very excited that this is going to be a moment to really turn it back on the ATF. So that's exciting. It's not terribly exciting for the victim of the government's prosecution, but he's in incredibly good spirits, and he has faith, right, going forward that justice will be done, and so do we. In the Fourth Circuit, there's another gentleman who was also convicted of selling machine guns. We didn't represent him, but we'll be taking his appeal. So basically, the ATF has a list of acceptable things, right? And you can't import machine guns and sell them into this market. You're just not allowed to do it. You gotta cut them up into little pieces, okay? And when you cut them up into little pieces, they're not considered a machine gun anymore. They're just chunks. ATF literally approves you to do this and says, okay, that's not a machine gun, it's chunks, you can sell it. Like, and you can buy them at like bodegas and online, and you can buy them with a credit card. Every once in a while, ATF's like, okay, well, you gotta cut it different now, right? No big deal, they cut them different, and they keep selling them. A 23-year-old kid was selling one of these cut up pieces online, where they had sold. The ATF had a rat, confidential informant, and they told him, go on that internet and find us somebody selling a machine gun. And would you believe that he couldn't find anyone? He couldn't find anyone openly selling illegal machine guns online. Can you believe that? Anyway, so we found one of these cut up kits. And he goes, oh, ATF, I got it for you. This guy's selling machine guns. And he buys the cut up kit. And he brings it to the ATF. And they're like, this is the machine gun? Yep. The very thing that ATF approved to be sold to ordinary people, their rat bought, said it was a machine gun, and he's facing 20 years now. The state of our law is pretty messed up. Effectively, ATF is standing for the proposition that they can thought crime, right, a machine gun into existence. I think those should be pretty easy cases to reverse. But it's scary. Especially, the human element of these cases. Tate is the guy in the Fourth Circuit. He was getting ready to get married, he was a sailor, right, all this stuff, and now he was sentenced to 20 years for cut up little chunks that ATF said, yeah, those are fine, you can bring them in. It's pretty incredible. We're suing in Tampa over the pistol brace definition. That was where ATF basically said out of nowhere, oh, these handguns, like everyone can have them, these basically big handguns, they're fine, they're fine, they're fine. And then one day they said, actually no, if you have one of those, you get to go in the special cage for like 5 years. And we said no, and then we got pretty good preliminary results. And all of the major groups that are bringing these cases in other districts are bringing them solely on procedural grounds. And we're like, well, what's that going to win us long term, right? So we're moving specifically to declare this a constitutional rights violation. We are moving on Second Amendment grounds. Because we feel that's the result that should be sought for. So that was all he asked me to give you guys an update on the legal stuff that we were specifically doing. But that's what I have for y'all. If y'all have any specific questions on firearms law and regs, I'm happy to take them. It's literally all I live and breathe because I'm so boring and miserable.
So last week I was reading an article online, I didn't know this was a thing, but in a place like Tennessee, they're saying you can't have the right to vote if you're a convicted felon. So if you want to regain the right to vote, you have to have all of your rights restored, meaning you have to have your gun rights restored. And I'm just wondering if using that angle would be a nice backdoor way of getting felons' rights to own a gun back, because you can use those say, well, I can't vote, and people are asking, well, why are you not allowing them to vote? I don't think I'm ever wondering if that might be a novel way of getting some people their right to own firearms back.
So I think that's a really important thing, and what you had said was whether, because there's this recent resurgence of a rights restoration, felon voting rights to be reinstated, whether that is a good vehicle to push for firearm rights restoration. I think that's something that people don't think about often enough, is just how pernicious and evil permanent rights deprivations are. That's actually something I do in my law practice. I can't tell you how many people I have represented who did something so unbelievably innocuous, but felonious, right? I mean, I do believe if you purchase sawdust from a source that's not reputable, and you then use the sawdust in a product that's sold interstate, you lose your gun rights for your whole life. Also something about like poppy seeds. But yeah, there's a million felonies that you can lose your gun rights for forever. And that's intensely dehumanizing. But everyone's willing to accept that it's dehumanizing to lose your voting rights forever. But there's a principal distinction there, right? I mean, I'm among libertarians, so I might be among friends, but I don't think voting actually matters that much. But you know what really, really matters? The ability to decide whether or not somebody else can just destroy you at any point. Because that's what the right to armed self-defense is, when you reduce it to its core component parts. Without a right to armed self-defense, it means that a bad actor gets to decide whether or not you are alive. The right to armed self-defense means you have the opportunity to contest that, right? If you put those at their core component parts, which is more valuable? The right to direct your human autonomy against a bad actor? Or the right to select government lizards? Right? I mean, there's debate, right? I mean, obviously I'm downplaying significance of voting. Voting is very important. Vote for all of the libertarian candidates. But that's a principled argument. And I think there's a huge principled reason that people who are convicted of nonviolent crimes, and even people who are convicted of violent crimes, isn't there supposed to be a presupposition that once they have served their sentence or done, whatever flaming hoops they're told to jump through? Or do we just do that for fun? It seems that way. If they're going to be punished forever and chained to the prison once they're released, then why are we making them jump through the flaming hoops? We're not even televising it if it's just for entertainment. So I do think it's an important thing to bring up. And I think that, to your point, the way to bring that up is like, if somebody's pushing for that, you should just attach rights restoration, firearm restoration to that. And just say, absolutely they should be able to vote. They should be able to decide who their representatives are in state and local government, just like they should be able to protect themselves. And if somebody can sit there and go, whoa, right? I think you've got a rat on your hands right there. Yeah, thank you for that. That's a good point.
So I have a question, which you remind me of. I'm not
I'm
sure if
sorry.
I'm going to phrase it. But generally speaking, why is it so rare that cases are brought on rights deprivation or constitutional provisions rather than stuff like procedural grounds or existing law violations, rather than the actual founding document our country was based off of?
Right, so the question is, why are so many cases based off of procedural issues, legal technicalities, rather than actual hard constitutional rights deprivation? And that's because the cards are stacked against us. It's very hard to plead a constitutional issue. There has to be, and it's because of a mistake in our Constitution. Article 3, the requirement, Article 3, as it's been interpreted, the requirement of standing, is a defect. And basically, you can't just assert a rights deprivation without an instant case or controversy. So the way we hooked the rights deprivation in the pistol race cases is basically that I found some Floridians that were hardcore enough to say, I'm breaking the law, and I'm scared you're gonna put me in the special box. That was our hook, right? They're like, I'm doing this. I'm breaking the law, right? And so most people don't want to do that. Most people don't have that specific breed of hardcore blood, especially when they're institutional plaintiffs, right? But those people do exist, and that's how you get it. The other thing is that lawyers are often, especially on the institutional side, institutional lawyers hate bringing those cases because they're like, oh, what if they get in trouble? Oh, what if the person who agreed to say that they're breaking the law gets in trouble? It's like, yeah, well, that's why no one will remember your name. So, but that's why. It's because it's hard technically, and it requires people to really put their necks out. That said, I've never seen anybody actually get in trouble for doing this because it would be unbelievably bad form for the government, right? But that's kind of the reason. It's much cleaner procedurally and technically to say, this is the requirements of the Administrative Procedures Act, and if you look under this subsection, you didn't do that, and so that's all we need to prove, right? Thanks for that.
Have you used, outside of the Second Amendment, have you used other amendments to fight some of these cases, like the First Amendment, when it comes?
Oh, so the question is, outside the Second Amendment, have we used constitutional guarantees to fight these cases? Yeah. So in the key card case, we made First Amendment arguments, and I think those are important. Fifth Amendment arguments are incredibly important. 14th Amendment incorporates these arguments against the states. I'm still looking for a Third Amendment case. But yeah, no, it's, I mean, the Constitution it has to be read as a complete document. The problem is that the courts have kind of collapsed a lot of distinctions that are really important, like privilege and immunities clause, just like, they just murdered it in cold blood. But yeah, a short answer to your question is yes, we tend to use the whole document. Anyone else?
I'll follow up to my previous question, I guess. So you've mentioned before about how arguing Bruin, going up to the judge and saying Bruin doesn't work out very well. I'm just curious what your opinion is generally on the Bruin decision and then Heller and McDonald previously.
So the question is, what's my opinion on Heller, McDonald, and Bruin, which is the trilogy of Second Amendment cases that the Supreme Court has actually ruled on. And my opinion is that Heller was a intensely milquetoast and uninformed opinion that I also believe was wrong. Not wrong in result, but wrong in its methodology. And the reason I think Heller was wrong is because in its 60-something page penumbra, I've often challenged people to tell me, where is the test, where is the analysis I must apply to cases moving forward? And you can give that to 10 lawyers, and they will all hand you 10 equally idiotic nonsense answers, because there is no law in Heller. It was basically a series of compromises from a intensely politically divided court over a question so fundamental in court as to, can you have an operable handgun in your house, right? The court was so compromised that they couldn't have a clear-cut decision on, can you have an operable handgun in your house? So, Heller was, there's almost nothing you can point to in Heller aside from the fact that court said, handgun, I'm allowed to have it. McDonald just says, that applies to the states. And Bruin, though, is where we finally take a step forward, but it's not much, because it's still so intensely deferential. And because what Bruin tells us is, no. We apply the Second Amendment every single time the government's activity implicates the right to keep and bear arms. Period. We apply the Second Amendment. Okay, so what does applying the Second Amendment mean? Well, it means you have to find a historically analogous law to the instant deprivation. And that doesn't mean a twin. Well, we're not going to say exactly when, but maybe the founding. Right? Like, it's very loose, and our 11th Circuit has already cocked that up hardcore, desperately, as it broke its back to defend Florida's 21 and over gun purchase requirement, where, and I think the obvious answer is that it has to be at the founding, right? Because when's the other point that's relevant? Well, that would be the 14th Amendment, and there was a bit of a thing happening. At the time, there was some folks of a certain color that was treated wrong, and especially about guns, and those laws were on the books until the 1960s. So I think it's problematic to rely on Reconstruction era laws, and yet the 11th Circuit's like, well, before it wants to ban guns, so yeah, Civil War, yeah, that's good. We'll go with that. Right? So that's already like a huge problem. And they are revisiting that case, but that was under Bruin, because Bruin didn't say 1791, right? So the 11th Circuit, following Bruin, was like, what if we just find some racist Georgia law that says whatever? Yeah, they said certain people can't have guns, so Florida can say certain people have, right? That was under Bruin. So, right? I think a simple test. Here's how I would have written the test. Me, an insane person. Here's how I would have written the test. Does the law affect the simple, peaceable keeping of a firearm? If yes, overturn it, right? And so that's to say, well, like, what laws do people often say, what laws do you think could be passed? I think anything that's consistent with common law nuisance, right? So, a law that says you get double whatever if you use a Turkish gun. Whatever. Fine. I don't think that really implicates any constitutional protections. I don't think there's constitutional protection to do crime with a Turkish gun, right? Then the other thing is, a law about, let's say the city of Huntsville wanted to say, hey, we don't think you should be keeping sarin gas canisters around. Well, that might be peaceable, but, sarin gas has a way of wandering around, right, and posing concerns for people in a kind of general nuisance fashion. So that can be done, and that doesn't even involve the Second Amendment. That's a simple nuisance question, right? Before and after the founding of our nation, it was clear that you weren't supposed to blow your neighbor's property up or pump gas into his house, right? People didn't debate this. You're not supposed to do that. And so I think that arms regulations consistent with, hey, don't blow your neighbor's house up, if he didn't hurt you, would be fine, right? And I think would accomplish all of this stuff. Like the parade of horribles, people say, oh, you just want recreational nukes. And it's like, yes, I do. But I don't think that I'm going to get that because of the nuisance concept. It's not the Second Amendment that is going to protect keep me from the recreational nuke. It's the fact that it's a nuke. Right? But yeah, good question. Thank you. Is that all? I can't tell. What?
Did you have a success in the 11th Judicial Circuit?
The 11th. So we're looking at, we're just now advancing into the 11th Circuit litigation ourselves. So we haven't had success or failure yet. But we're seeing the 11th Circuit reconsider its intensely racist prior holding because it actually, on its own, without the filing of another lawsuit, literally said, hey, let's relook at that one. And the whole court is re-examining the Bondi decision there. So that's a very good sign because the whole court wouldn't re-examine a decision that they thought they did correctly, right? So I think that's a very good look for the 11th Circuit. And it's also going to bring them into, what they're probably wanting to do is bring themselves more into parity with our sisters in the 5th Circuit. Because we generally get along. Texas is okay, I guess, right? You have a follow-up?
I was just wondering, because here in Alabama, it's like a different world. And if you Google all of those judges, especially if you Google gay born naked judge, you'll find the top judge in the application.
Yeah, so I went to law school here.
Oh, okay.
I know.
Okay.
Yeah, this place is weird. I went to University of Alabama. I guess, I guess you're welcome for some of the Florida judges, like bringing the sanity like slightly, but we're Floridians, so it's like we bring sanity, but also like the meth concentration, So we're not a perfect circuit, but I mean, at least we're not the 4th or the 9th Circuit, right? So I guess, thank God, I don't know. It's all terrible. Yeah. Sir?
I can stand before you as someone who has in fact brought a Third Amendment case to the 11th Circuit. So there were other folks that were living in my home that I held legal title to and paying taxes on. We won unanimously in the United States Supreme Court in 2005. I got bucked back down to Myron Thompson, sent it back up to the Supreme Court, and they wouldn't even hear it the second time. So I don't know how you go from winning unanimously to it not even being heard again. So if you want me to talk about my Third Amendment case, I don't want to waste folks' time here.
No, I love you telling me that.
But my question is, and this is specific to us in Lee County, there was a black entrepreneur at a curbside pickup service. The county did not like it, accused him of wrongful dumping, this, that, and the other.
Why would Robert E. Lee County not like him?
Well, that's another issue. So with respect to these corrupt county commissioners who seem to have the spirit of discrimination, all of those sort of stuff.
No.
Basically said, you can no longer do your business, which in my opinion is a Fifth Amendment taking. But they're now sending out fraudulent bills that about 7,900 people in Lee County are not paying. We have turned it over to the federal postal inspector for mail fraud. Like they're sending bills to folks that are not contracted for. I understand my corrupt county is obliged to pay, but don't send me a bill on top of my tax dollars paying for corruption. My question to you specifically is, how do I go about finding someone willing to do a class action suit with 21,000 victims that are very easily defined, right? In your motion to produce, please give us the names that you sent these 21,000 fraudulent bills to. And is there any way you can, not just tell me, but tell others how you can get folks to go after that?
My immediate thought is, does Alabama have a... So the fascinating story was that we have a Robert E. Lee County in Florida too. It's funny. There's a black entrepreneur who is doing trash pickup,
Correct.
which is so awesome. Did he also have like a little shop where he kept all the Virgin Marys?
Well, there were 4 competitive, private entities doing 2 of the 4 were black. The one most successful one, who had the audacity to go before the commissioners and say, how can you charge me with wrongful dumping when it clearly wasn't going on?
Right.
And it was a full-bore event to destroy this entrepreneur.
And so he was collecting trash, was charged with illegal dumping, which is hilarious. And now the county is sending bills to 21,000 people. And so the question is, how do you sue them for that? So the answer is you have to get creative with stuff like that. And so and that's the thing. And this is this is a defect of state constitutions, because they borrow from the way our federal courts are set up. They similarly have these defects in that simple taxpayer standing doesn't exist.
Correct.
Which is so, I'm sorry, it's retarded. Like, that's an obvious injury, but there's no direct way, there's no easy way to do that. So, the thing that my little rat brain does is immediately goes to, does Alabama have a consumer protection bill collection statute? It probably does, and that's. I'd love to hear more about this, because I think something really funny could happen, and the government hates it when you do that. They hate it when you get all funny. But yeah, we'll
They're
talk.
paying 7,900 people not paying the
Yeah.
fraudulent bill.
Yeah, that's good. All right, anyone else? All right, with my bad vision, I don't see any more hands. Thank you all so much. I very much appreciate it.